Section 16 of Tribal Custom and Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom and Anglo-Saxon Law by Frederic Seebohm. Chapter 7. Tribal Customs of the Tribes Conquered by Charlemagne. Part 2. 2. The Lex Frisiorum. The tribes conquered by Charlemagne, whose laws we have now to examine, differed from those whose laws and virgils had been already considered in one important particular. They were not conquering tribes which had migrated into districts already under Roman law. The conquests of Charlemagne over the Frisians and Saxons were a conquest of German tribes settled as a fold in their own countries. They were, moreover, conquest of still pagan tribes by Christian and partly Romanized Franks. Frankish conquest had extended far into Frisian and Westphalian territory under the Merovingian kings. In Frisia, Frankish influence was shown by the existence of Merovingian mints at Dürrstedt. In Westphalia, at Soest and Paderborn, there were already Christian churches under the jurisdiction of the Archbishop of Cologne. But neither the conquest nor the conversion was completed till the time of Charlemagne. We have already learned from Titles 31 and 36 of the Ripuarian law that there were Frisians as well as Saxons, Burgundians, Alemanni, and Bavarians resident in the Ripuarian district. Moreover, it was directly stated that these immigrants were to be judged not by Ripuarian law, but by their own law and custom. Further, being often isolated and without kindred near them to swear for them, if charged with crime, they were to clear themselves by the ordeal of fire or lot. And finally, their vergeld was stated to be 160 solidi, the inference being that this was the vergeld of the Frisian freeman in his own country, by the law and custom of which he was to be judged. So that we approach the text of the Frisian law with this valuable earlier knowledge in our possession. 2 centuries before the date to which the collection of Frisian laws is assigned, the Ripuarian law bears witness that the Frisian vergeld was 160 solidi. Even if these clauses were not a part of the original text and did not date back to the 6th century, the inference would be strong, and perhaps all the stronger, that such must have been the vergeld at the later date of the Frisian law. This earlier evidence is important as, without the clue it gives us, and with nothing but the Frisian law to guide us, we might very easily have been led to a wrong conclusion. There seems to be no text of the Frisian laws earlier than that published by Harold at Basley in 1557, and he does not state from whence he obtained the text followed by him. Moreover, it is clear from internal evidence that the laws as we have them are by no means of one single date. They form, in fact, a collection of the customs of the 3 districts into which Frisia was divided, with modifications and various additions made to the original collection at different times. At first sight, there are inconsistencies in the statements of the vergelds, and, as in other cases, the key to an understanding of them is to be found, to some extent, in close attention to the currencies in which the amounts of the compositions are stated. It is not necessary to enter into any discussion of the various theories suggested to meet the difficulties caused by the confusion of the various currencies. The knowledge already obtained in the course of this inquiry will, I think, if adhered to, suffice to clear the way sufficiently for our purpose, bearing in mind that the Lex Frisiorum, as we have it, is a compilation with various additions. The inconsistencies in the text will be no surprise, provided that the reason for their occurrence is apparent. Frisia was divided into 3 divisions, and in each glosses, which appear late in the laws. We are told that each division had a separate solidus of its own. 1. Between the Laubach and Weser, the northern division, The solitus is described as 2 denarii, i.e. tremisses, of the nova moneta. This solitus, we shall find, was like that of the Saxon tribes on the eastern side of the Weser. The solitus, being of 2 tremisses, contained 64 wheat grains of gold. 2. In the middle division, between the Lawbeck and Flea, the solitus is said to have been of 3 denarii, or tremisses, of the nova moneta, i.e. 96 wheat grains of gold. This solitus is the gold solitus of 3 tremisses after it had been raised by Charlemagne to the standard of the Eastern Empire. 3. In the southern or western divisions, between the Flea and the Sinfal, the solitus was 2.5 denarii or tremisses ad nova monetum, i.e. 80 wheat grains of gold. But it seems to be clear that the statements of the vergels and other fines in earlier clauses of the laws are not made in these local solidi. Thus in Title 16 we are told that inter lobaci et syncphalum, i.e. in both middle and southern divisions, in cases of homicide the payment to the lord for breach of his peace, defreda, was 30 solidi, which solitus consists of 3 denarii, although the locus solitus of the southern division was that of 2.5 tremisses. Sometimes the fines are stated in solidi of 3 tremisses, and sometimes in solidi of 20 to the pound. There is no difficulty, after what we have seen in other laws, in recognizing in the solitus of 3 tremisses the gold solitus, and in the solitus of 20 to the pound the silver solitus of the Frankish Empire. Again, we at once recognize in the term nova moneta, the new standard of Charlemagne, and in the term veteris denarii, which also occurs in the laws the gold or silver tremisses of the Merovingian currency before the monetary reform of Charlemagne. All this is exactly what might be expected in laws of somewhat different dates, some of them perhaps going back to the time of the Merovingian conquests, and others following upon the conquest of Charlemagne. Having thus so far cleared the way, we pass on to the amounts of the vergels as stated in the lex. Title 1 is headed Incipit Lex Personium, et hec et simpla composito de homicidis, and the vergels of the 3 districts as stated in the text and clauses may be tabulated as follows. 1. Between the Laubeck and the Weser, Nobens 106 solidi and 2 denarii or tremisses. Labor 53 solidi and 1 denarius. Lettuce 26.5 solidi and 1/2 tremisses. 2. Between the Laubeck and the Flea, Nobilis 80 solidi payable 2/3 to the heir of the slain, and 1/3 to his propinquis proximi. Labor 53 solidi and 1 denarius, i.e. tremisses. Litis 27 solidi less 1 denarius, payable to his lord. Litis 9 solidi less 1/2 denarius, payable to the propinqui of the slain. 3. Between the Flea and the Sinfal, Nobilis 100 solidi, labor 50 solidi, of 3 denarii, i.e. tremisses, novi moneti. Litis 25 solidi, of 3 denarii, i.e. tremisses, novi moneti. These vergels, with one exception, are alike throughout, so far as regards the proportions between the 3 classes. The vergeld of the labor is double that of the litis, and that of the nobilis double that of the labor, except in the middle district, in which the vergeld of the nobilis is only 1.5 times that of the labor. In the same district there is an additional payment to the propinqui of the litis, his proper vergeld, half of that of the labor, going to his lord. It will be observed that in the last district only are the denarii, i.e. tremisses, stated to be novi moneti. The influence is that in the other 2 districts the tremisses, and therefore the solidi, were of the lower Merovingian standard. The district in which the tremisses were novi moneti was the southern district, first conquered and most thoroughly brought under Frankish influence. The other two districts had apparently not yet so completely come under it. Accordingly, if we take the 106 and 2/3 solidi of the nobilis of the northern district to be of Merovingian standard, the result is 106.5 times 86.4 wheat grains, 9,216 wheat grains, or exactly 16 Roman ounces, i.e., the mina called, as we have seen, the Attic mina, which in Scandinavian usage was divided into 2 gold marks. The vergeld of the nobilis in the metal district between the Laubach and the Flea is stated to be 80 solidi instead of 106 solidi and 2 denarii. But as the vergeld of the Liber and Litis are the same as those of the northern district, and therefore also presumably expressed in Merovingian currency, the vergeld of 80 solidi of the nobilis, to be consistent, should be also of the same Merovingian standard, and so it seems to have been, for 80 Merovingian solidi, 80 times 86.4 wheat grains, make exactly the Roman pound of 6,912 wheat grains, or 12 Roman ounces, i.e., 1.5 gold marks. In the vergelds of both northern districts, therefore, an original reckoning in gold marks of the Scandinavian system seems to have been afterwards translated with exactness into an uneven amount and fractions of solidi of the Merovingian standard. We may therefore state the vergelds of the two districts north of the Zuyder Zee in marks of the Scandinavian system thus: nobilis, 2 or 1.5 gold marks; Liber, 1 gold mark; Litis, 1/2 gold mark. That these vergelds could be stated thus evenly in gold marks of the Scandinavian system, whilst in Frankish solidi they could be stated only in uneven numbers and fractions, is an interesting fact. It seems to show that the original vergelds went back to a time when the trade intercourse of northern Frisia was connected mainly with Scandinavia, the Baltic, and the eastern trade route. In Beowulf, we found that Frisia was on the horizon of the area included within the vision of the poet, the interest of whose story lay chiefly in the Baltic. Now let us compare the vergeld of the Liber in these districts, viz. 53 solidi and 1 tramissus of Merovingian currency, with what the statement in the Ripuarian law would lead us to expect it to have been, viz. 160 of the same solidi. It is exactly 1/3 of what it ought to be, and the inference from what we have learned in the last section would be that the maker of the laws had divided the vergeld of ancient custom by 3. But for the moment we pass on to follow further the text of the Frisian laws. In section 11 of Title 1, it is enacted that if anyone, whether nobilis, liber, or litis, or servus, shall slay the service of another, he shall compound with the service according to his value. And in section 13 of the same title, it is stated that if a slave shall kill either a nobilis or liber or litis, unknown to his lord, the lord of the slave shall swear that he did not order it, and pay twice the value of the slave. But if the lord cannot deny that he ordered it, he must pay for the homicide as if he had done it with his own hand. In Title 4, it is again enacted that if any one shall kill the slave of another, he shall be compounded for it the value put upon him by his lord. And the same rule is made to apply to the case of a horse, ox, sheep, goat, pig, and all domestic animals, except the dog. They are all to be paid for at the owner's estimate of value, or the alleged slayer must clear himself with as many oaths as the judge may require. The dog is the only animal whose value is fixed by the law, and its value at first sight was not the same in the several divisions. Dog for hawking, between Laubach and Singfrau, 4 solidi, between Laubach and Weser, 8 solidi and 12. Wolfhound accustomed to kill wolves, 3 solidi between Laubach and Singfal. Wolfhound which wounds but does not kill, 2 solidi between Laubach and Sinfalk, 8 solidi and 12 between Laubach and Weser. Shepherd dog, 1 solidi between Laubach and Singfal, 4 solidi between Laubach and Weser. The difference between the value of the dog in the northern and the other divisions can hardly be other than one of different currencies. Probably the values for the northern division may be silver values. It may, however, be remarked in passing that the value of a dog in any case is not likely to be regarded as excessive. Its high value in the Frisian laws, and also in other laws, shows how dependent the tribes surrounded by forests were upon its help. In the Cymric codes, as we have seen, the herdsman dog was worth as much as an ox. In Alemannic laws, the shepherd dog which could kill a wolf was valued at 3 gold solidi, or half as much as the best ox. And in the Lex Salica, the Canis Pastoralis was valued at 3 solidi. It is not difficult, therefore, to understand how in Frisia the dog which could kill a wolf should be worth 3 gold solidi, and the ordinary shepherd dog a gold solidus. We now come to a set of clauses in which the differences between the 3 districts appear again, and in one of which, viz., again the district between the Laubach and the Weser, we meet with values stated in silver solidi of 20 to the pound, i.e. of 12 pence. These clauses are interesting as illustrating Frisian methods of compurgation, the ordeal of the lot and of hot water, and trial by battle, all of which evidently belong to ancient tribal custom. Title 14 relates to the slaying of a man in a crowd, and describes the means taken to ascertain whose deed it was. Each division has its own custom. That of the middle district is first described. The relative of the slain may summon 7 men and charge each of them with the crime, and each is then put upon his oath with 11 co-swearers. Then they are to go to the church, and lots are to be cast upon the altar, or if the church be too far off, the lots are to be cast upon relics. The lots are to be 2 pieces, tally, cut from a rod and called tenny, on one only, of which is the sign of the cross, the other being left blank. A clean cloth is to be spread over the altar or the relics, and then the priest, or if none, an innocent boy, ought to take one of the lots from the altar and pray God to show by some evident sign whether those 7 who have sworn truly. If he takes up the lot marked with the cross, then those who have sworn were innocent. But if it takes up the other, then each one of the 7 makes his own lot from a rod, and marks his own sign on it, and so that both he and those standing by can recognize it. And the lots shall be wrapped up in clean cloth and laid upon the altar or relics, and the priest, if he be there, and if not, the innocent boy, as above, shall take up each of them one by one from the altar, and shall ask him who knows it to be his own lot. And he whose lot happens to be last shall be compelled to pay the composition for the homicide. The rest, whose lots have already been taken up, are absolved. But if, in the first trial of the 2 lots, he takes up the one marked with the cross, the 7 shall be innocent, as aforesaid, and he, the accuser, if he wishes, shall summon others for the same homicide, and whoever may be summoned ought to clear himself by complete oath with 11 co-swearers, and this shall be enough for the accuser, nor can he bring any one further to the lot. This law prevailed between the Laubach and the Flea, between the Flea and the Sinkfall. For a case of this kind the following was the custom. He who seeks composition for a homicide shall swear on saints' relics that he will not summon in this manner other than those who are suspected by him of the actual homicide, and then he shall summon for the homicide 1 or 2, or even 3 or 4, or however many there may be who were slain. But though there were 20 or even 30, yet not more than 7 are to be summoned, and each of those summoned shall swear with 11 others, and shall, after the oath has been tested by the judgment of God, show himself innocent by the ordeal of boiling water. He who swears first shall go to the ordeal first, and the rest in order. He who shall be found guilty in the ordeal shall pay the composition for the homicide, and to the king twice his own vergeld. The rest of his co-swearers shall be treated as above concerning perjurers. Between the Laubach and the Beza, the following was the custom. He who seeks composition for homicide shall summon one man, declaring him to be the homicide of his kinsman, and saying that he ought to pay the lewd of the slain man. And if he, in reply, says that he is willing to purge himself on oath with his co-swearers, let him who has summoned him as homicide say that he wishes to summon him in placitu publico, and let him so do. Let him summon him in placito before judges, and let him who is summoned, if he cannot deny, show another defendant for the homicide of which he is accused, and this ought to be done thus. Let him produce the man he wishes, and let him swear, he is guilty of the homicide for which I am summoned, holding him by the hem of his cloak. But if he wishes to deny this oath, let him swear and go forth to wager a battle against him, and whichever of them in the battle is conquered, et sivi concrediderit, shall pay the lewd of the slain. But if he be slain, his next heir shall pay the composition of the homicide. But in this battle it is lawful for either to pay a champion for himself, if he can find one. If the hired champion is slain, let him who hired him pay 60 solidi, i.e. 3 libri, to the king, and over and above pay the lewd of the slain man. The payment of 60 solidi, i.e. 3 libri, clearly indicates that the solidus of this clause was the Frankish silver solidus of 12 pence, of which 20 made the pound of silver, and this helps us to understand that the compositions described in the immediately succeeding and closely connected clause are also silver values. Title 15. This is the custom in the same region observed for the composition of vergeld. 1. Composition of a nobilis homo per denarius veteris, 11 pounds. 2. Composition of the liber per denarius veteris, 5.5 pounds. 3. Composition of a litus, of which 2/3 pertains to the lord, 1/3 to his kinsman, 2 pounds 9 ounces. 4. Composition of a service, 1 pound 4.5 ounces. There can, I think, be no doubt that the libri of this clause are silver pounds, and further, that as they are stated to be pounds per denarius veteris, they must be pounds of Merovingian and not of Carlovingian weight. The pounds of this statement are therefore Roman pounds of 240 Merovingian pence. Let us compare that the vergeld of the liber of 5.5 such pounds of silver with the vergeld of the liber as stated in Title 1, which we saw was equivalent to 1 mark of gold. Following the Scandinavian ratio of 1 to 8, the mark of 8 ounces of gold would equal 64 ounces of silver, i.e., 5 pounds instead of 5.5. The silver vergeld of the nobilis would equal 10 2/3 pounds instead of 11. The reckoning is rough, but near enough to justify the conclusion that what was aimed at was the nearest even pound of silver, and that therefore the vergeld of the one statement is the equivalent of the vergeld of the other statement. At the same time, the fact of the reckoning being throughout in Roman, i.e. Merovingian pounds, and not in those of Charlemagne's Nova Moneta, is instructive. It shows that this clause belongs to the period during which the silver currency was pushing its way into Frisia. A reckoning in silver had become necessary, although, as we happen to know, the Frisians had a special liking for gold. They continued to coin gold much longer than the Franks, and some years later than the date of the laws. The Frisians were in close contact with the mint at Dürrstedt, which was in fact the commercial metropolis of the north at the date of the laws. The mint at Dürrstedt continued to coin gold coins till the city was destroyed by the ravages of the Northmen in AD 837, and it was from these Durstedt Frisian coins that the types were taken of the first Scandinavian coinage. In the meantime, the close connection between Frisia and the Scandinavian district is quite sufficient to account for the Scandinavian ratio of 1 to 8, being the one used in the translation of the gold vergeld of the district next to the Weser into a silver equivalent. Let us now at last translate the vergelds of the three Frisian districts, as stated in Title I, in gold solidi of 3 tremisses, back again into what must have been when reckoned in the local solidi. If originally they were reckoned in these local solidi, the result should be in even numbers. Between the Laubach and the Weser, nobilis, 9,216 wheat grains, equals 144 solidi of 2 tremisses or 2 gold marks. Liber, 4,608 wheat grains, equals 72 solidi or 1 gold mark. Litis, 2,304 wheat grains, equals 36 solidi or 1/2 gold mark. Between the Laubach and the Flea, nobilis, 6,912 wheat grains, equals 72 solidi of 3 tremisses or 1.5 gold mark. Liber, 4,608 wheat grains, equals 48 solidi or 1 gold mark. Litis, 2,304 wheat grains, equals 24 solidi or 1/2 a gold mark. Between the Flea and the Sinkfal, nobilis, 9,600 wheat grains, equals 120 solidi of 2.5 tremisses. Liber, 4,800 wheat grains, equals 60 solidi of 2.5 tremisses. Litis, 2,400 wheat grains, equals 30 solidi of 2.5 tremisses. It is interesting to observe that the vergelds of the two districts north of the Zuider Zee, when translated back into the local solidi, turn out to have been in even numbers of such solidi, as well as in even gold marks of the Scandinavian district, whilst those of the southern district most under Frankish influence make even numbers of the local solidus but not of the mark. When these Frisian vergelds and local solidi are regarded in connection with the fact that the vergelds on the east or Saxon side of the Weser were, as we shall find, also paid in a local solidus, and that this Saxon local solidus, like the solidi of the North Frisian district, was of 2 tremisses, and further that it represented the value of the 1-year-old bullock. We are led to conjecture that the Frisian local solidi also may have represented the animal in which the vergelds were originally reckoned and paid, and this may perhaps be confirmed by the fact that, down to comparatively modern times, the East Frisian silver currency consisted chiefly of the golden, at its 1/10 the sharp. Possibly the golden of this silver currency may point back to a time when the gold piece was reckoned of the value of 10 sheep. But this is conjecture only. The dog, as we have seen, was the only animal whose value was fixed in the laws. The fact that the gold and the silver values of the vergelds of Todus 1 and 15 of the Lex seem to correspond leads up once more to the difficult question whether the vergeld of the Liber should be exactly 1/3 of what the Ripuarian law apparently declared it to have been. Richthofen, in his preface and notes to the Frisian laws in the edition of Pertz, points out that in later additions to the laws there is a curious duplication and triplication of figures, which has to be accounted for. The facts seem to be these. In Title 22, Dedulge, relating to the Middle District and forming part of the more ancient law, the fines for wounding are first given for the Liber, and then an explanation is made in the epilogue that those for the nobilis were 1/3 higher, and those for the litis 1/2 less. The composition for the eye is stated to be half the vergeld. Then, under the heading Addita Sapientium, Title 2, the amount for the land is stated to be 25 solidi et 5 denarii, and after the mention of the amounts for the several fingers of the words, hoc totum in triplo componitur. The payments for hand and eye are generally alike, and 3 times 25 solidi and 5 denarii equals 80 solidi, i.e., half a vergeld of 160 solidi. Immediately following these Title III begins with the statement that the foot entirely cut off is to be compounded for as the hand, i.e. by 53 solidi and 1 trimissus, being double the previous amount. The payment for the eye put out is per quadraginta solidi, i.e. 120 solidi. Then, was in the title de dog, the ear is valued at 12 solidi. In Title III of the edito, it is valued at ter duodecim solidi. Again, according to the title de dolge, if both testicles were destroyed, the whole vergeld was to be paid. And in Title III of the edito, the fine has become ter 53 solidi and 1 trimissus, 3 times the vergeld of the liber in Title I. It is not needful to pursue the comparison further than to point out that Richthofen had some reason at any rate to form the opinion that in the additions to the law made, as he thinks after AD 785, and probably about AD 802, the vergelds were trebled, as well as some of the payments for wounds, and that the inference from the Riporient laws of the Frisian vergeld was 160 solidi was therefore correct. So far, Richthofen's contention is, I think, a correct one. But what was the reason of this trebling of the vergeld in the additions to the laws? Was it that the ancient vergelds were originally 1/3 of those of neighboring tribes, and trebled at some auspicious moment to make them correspond with others? Or have we not rather to do with the results of that confusion in the currency, which is caused by the endeavor to force into use the silver solidus of 12 pence as the equivalent of the gold solidus? This conjecture, standing by itself on the evidence of these laws alone, would be too hazardous to build upon, and it is not necessary to consider it further in this place. The matter of chief importance is that, all things considered, there seems to be fairly sufficient evidence that the weights of Title I represent the ancient vergelds divided by 3, and that accordingly we may take the vergeld of the liber in the 2 northern districts of Frisia to have been 3 gold marks or 160 Merovingian gold solidi, as stated in the Riporien laws. With regard to the distribution of division of the vergeld amongst the relations of the person slain, the laws mention only the custom of the middle districts, according to which 2/3 of the vergeld went to the heir of the slain and 1/3 ad procurbus proximus. They give no information as to how the propinqui proximi divided their third amongst themselves, or to what grade of kinship this class of relations extended. Happily, however, Dr. Brunner, in his informing essay on Sip and Vergeld, already quoted, has been able to supplement the meager information given by the laws as to vergelds with further details gained from later local sources. In his section on Die Friesen zwischen Zuiderzee and Weser, he gives an illustration of the way in which, under later custom, the payment of the vergeld was divided amongst the relations of the slain. He states that the North Frisian tally, i.e., the third share which the kindred had to pay, was known as the Mentella or Meitella, Magstel. In a legal document, Westerlaversches Friesland, the Mentella of the kindred is described as 4 pounds 5 ounces 6 2/3 pence, and the Erbserne, or 2/3, is to be paid by the heirs as 8 pounds 10 ounces 13 1/2 pfennig. The pound, we are told, is 12 ounces of 20 pence, so that here we have clearly Frankish currency and silver. The third and the 2/3 together make a whole vergeld of 13 pounds 4 ounces of silver. Now, in the first place, if, as we probably should do, we were to consider this vergeld to be stated in pounds and ounces, of Charlemagne's Nova Moneta. It would not be very far from treble the amount of the Vergeld of the Liber in Titles 1 and 15 of the laws. And this, so far as it goes, confirms the Raporian statement that the ancient Frisian Vergeld was one of 160 solidi. Let us now see how the third falling on the kindred was divided. The 1/3 of the mentella of the kindred moeg was divided thus. 1. The brother, or if none, the brother's son, or if none, the sister's son. 0 pounds, 12 ounces, 0 pence. 2. The uncle on the father's side, Fedria, 0 pounds, 9 ounces, 0 pence. The uncle on the mother's side, Eam, 0 pounds, 4 ounces, 0 pence. Or in default of these cousins of the slain, or in default the cousins of the uncles. 3. The Eftersusterburn, or cousins, descendants of grandparents. A. On the side of the father's grandfather, 0 pounds, 3 ounces, 8 pence. B. On the side of the father's grandmother, 0 pounds, 3 ounces, 8 pence. C. On the side of the mother's grandfather, 0 pounds, 2 ounces, 5 pence. D. On the side of the mother's grandmother, 0 pounds, 2 ounces, 5 pence. 4. The rest falls on the cousins, the 8 stems which descend from the great-grandparents, the 4 stems from father's side, 0 pounds, 7 ounces, 12 pence. The 4 stems from mother's side, 0 pounds, 7 ounces, 8 pence. Total, 4 pounds, 3 ounces, 6 pence. This interesting illustration of the payment of a Frisian Vergeld, though of later date than the laws, confirms the statement in the laws that in its division the immediate heirs of the slain took 2/3 and the propinqui proximi 1/3. It shows that at a later date the immediate Ebshone was 2/3 and the share of the kindred 1/3. And it adds the important point that the kindred who paid, and by inference shared in the receipt of the 1/3, were confined to the descendants of the great-grandparents, both paternal and maternal, of the slayer or of the slain. End of section 16.